Complying with Title II of the ADA. Um, I will just kind of recap the one disclaimer that she already offered and add a second. And certainly here at Accessible Web, we are digital accessibility experts, and we have a whole suite of tools and services to help you meet your compliance goals. We can provide guidance and resources, but we are not lawyers or legal experts of any kind. And so, any specific questions, please consult your legal team. And then the second thing I will say, just briefly, is that this is a pretty complex and nuanced topic. So, what you can expect from us today is kind of a top level overview to help you give you a good idea, get you started thinking about how this law in particular might apply to your organization, and get you thinking about next steps. So with that said, let's dive right into Title II. We'll move on to slide 2, please. Shout out to Mackenzie, my colleague who's running my slide deck today. All right, so on this slide, we're just going to briefly overview what topic areas we're going to cover. So first of all, we will very briefly define what is Title II of the Americans with Disabilities Act. Who does it aim to serve and protect? We'll cover 4 key elements of the law. We'll talk about some enforcement deadlines, which Gianna alluded to. We will be talking about some rare circumstances where there are exceptions to the Title II of the ADA. We will also talk about um, additional responsibilities beyond technical compliance that need to be considered in order to be fully compliant with Title II. Um, we will talk about how Accessible Web can help, and we'll wrap with a question and answer session. So moving on to slide number 3. Here we'll talk very briefly about what is Title II of the ADA. So as you may know, Title II is part of a larger landmark piece of civil rights legislation here in the United States. It was first signed into law in 1991, and here we are several decades in, still steadily making progress. Um, so, Title II specifically mandates that all programs, services, or activities provided by state or local governments must be accessible to individuals with disabilities. So examples of these government entities could include things like cities, towns, counties, municipalities, and individual state governments. Um, in addition to the government entities themselves, Title II provisions extend to other organizations run by those state governments, and that might be things like school districts or transportation systems and law enforcement agencies. That's not a comprehensive list, but those are just some examples to give you an idea. Um, as Gianna mentioned, Title II is particularly relevant right now due to a recent final rulemaking by the Department of Justice in April of 2024. And that rulemaking did a couple of things. It specifically included programs, activities, and services provided by state and local governments. They're provided online or through mobile applications. It also set forth specific technical standards that must be met in order to be in compliance, and it provided a timeline for implementation and deadline for compliance. All right, so in a nutshell, that's Title II and the way we're going to be talking about it specifically today as it relates to digital accessibility. All right, slide number 4, just very briefly, for anyone who's not familiar, the Americans with Disabilities Act provides protections uh, for individuals with all types of disabilities. So that includes physical and motor disabilities, sensory disabilities, cognitive and developmental disabilities, mental health disabilities. And I'm realizing just now as I'm saying this, I've missed communication related disabilities, speech and language and communication related disabilities. We can move on to slide 5. And now we are going to talk about 4 key components or elements of Title II. again, specifically as it relates to digital accessibility in this most recent rulemaking. So I touched on this before, but it bears repeating. All programs, services, and activities offered by state and local governments must be accessible to individuals with disabilities, including those programs provided online or through mobile applications. I think we're still on the same slide. I'm just switching up my notes. Um, let's see some examples specifically of what they consider um, content that's delivered online or through mobile applications are things such as websites, documents, electronic documents, mobile applications, and social media content. Some examples of the typical things we experience on websites in particular include, but are not limited to, things such as text, images, sounds, videos, and electronic documents. All right, the second key component to make note of here are the technical standards that were set forth in this most recent rulemaking. And so, as it stands, Title II requires compliance with WCAG 2.1 Level AA. If you're not familiar with this, WCAG stands for the Web Content Accessibility Guidelines. This is a framework of accessibility standards that are international. They are put forth by the W3C, or the World Wide Web Consortium, and they are considered the gold standard in web accessibility. All right, the third component that we need to consider here is these requirements, technical and otherwise, that we've just been discussing, um, also extend beyond the state and local governments and the other entities that might be overseen by them, which we mentioned earlier, like schools, transportation, etc. This also extends to include any third-party vendors who are contracted with state and local governments to provide any type of digital services or content for them. So, an example here might be um, a city provides public parking, access to public parking for the residents, but they use a third party mobile application for payment. It's then incumbent upon that city to make sure that that third party application they're using is accessible for their residents. Just pausing to grab a drink. All right, and our fourth element, key element here that we need to consider is something called equivalent facilitation. This is a provision in Title II that basically allows for state and local governments to provide their online and mobile app content at a higher level of accessibility than what's set forth in the current guidelines, which we mentioned earlier is WCAG 2.1 level AA. And so an example here to help make this make a little more sense is, since that ruling came out in April of 2024, WCAG has actually released um, version 2.2 of its guidelines and standards. And so, if a state or local government so desired, they could deploy their digital content at that level 2.2, which is equivalent and or higher level of accessibility than the one set forth in the regulation. All right, we can move on to slide number 6 now. We're going to review some possible exceptions to Title II. And I just want to be really clear here. There are some categories where there are some qualifying exceptions, but this should never be used as a means of trying to sort of dodge your obligation here for legal compliance. But it is a provision to allow for some extenuating circumstances. Um, I should say most of these exceptions are going to be rare, and in order to qualify for these exceptions, there are generally several very specific criteria that need to be met in each of these categories, and all criteria need to be met in order to qualify for an exception. We're not going to go into any of the like details or nuance of those, That's kind of beyond the scope, but know that they exist. Some categories where you may potentially find exceptions include things like archived content, pre-existing conventional electronic documents, content posted by a third party not acting on behalf of the government, either through contractual or licensing agreement or any other arrangement. Number four, individualized documents that are password protected and pre-existing social media content. And just for clarification, you see the word pre-existing in a couple of these examples. That in particular here refers to content posted prior to the enforcement deadline, which we'll talk a little bit more detail about here. But in this context, that's what the word pre-existing represents. Let's move on to slide 7, please. Now we're going to talk about something called conforming alternative versions. And what this refers to is sometimes state or local governments might try to have two different websites, one that's accessible and one that's not accessible. And this is widely discouraged and never considered best practice. The fact of the matter is, people with disabilities should be getting their information and service access directly from the same site as everyone else. Um, so, again, discouraged, considered a last resort. But there are a couple of specific situations where this could be deployed as an alternative, and that is only if the entity, the state or local government, is able to prove very specific and insurmountable legal or technical challenges with making their content accessible. And again, that's a pretty specific and nuanced process as well. Um, Slide number 8, please. All right, so now we're going to talk about just a couple of additional sort of legal obligations under the ADA in general. They apply certainly to Title II, but they are also apply across the board um, in ADA. So the first one is effective communication. So we just talked about a few reasons why, in rare circumstances, you might not be able to make certain content accessible. In that case, you would still be obligated to provide effective communication. Now, as it relates to digital accessibility, I'll give you an example to hopefully help it make a little bit more sense. And that is, for example, someone who's blind requests an archived water quality report from your website. It's not accessible, but an individual is requesting it. And so it does in turn need to be provided to that person upon request. Now, in this circumstance where you're considering what an alternative effective communication might be in this situation, there are three key things that you need to keep in mind. The first is that that accommodation needs to be made in a timely fashion. The second is that priority consideration needs to be given to the requesting individual's typical or preferred communication method. And the third is that the complexity, context, nature, and length of that communication should also be taken into consideration when making these determinations. So in the example where someone is requesting that inaccessible, excuse me, when someone's requesting that water quality report, some options for effective communication that you might discuss in working with that individual would be things like providing an accessible digital format, either an accessible PDF or maybe a Microsoft Word document. It could be provided in large print, it could be provided in Braille or even audio, just depending on sort of what that individual's preferences are and the complexity of sort of making those accommodations. All right, a second one that's not quite so specifically related to digital accessibility, but is an example of effective communication might be if a citizen is deaf and they want to attend a school board meeting and that school board meeting is not typically interpreted upon request, then an ASL interpreter would need to be provided if that is the individual's preferred method of communication. Okay, so those are just some adjustments that can be made in circumstances either where there are exceptions and content isn't accessible. um, or in this other circumstance where an alternative communication strategy is needed. All right, and the second piece here, so that was effective communication, and now we're going to talk about reasonable modifications. And this just, again, basically states that all programs, services, and activities need to be accessible to individuals with disabilities, and if for some reason they're not, then those state and local government agencies need to make reasonable modifications or adjustments to accommodate for that individual's um, with disabilities specific needs. So I'm going to give you a few examples here to hopefully have this make a little bit more sense for you. So in the first case, we'll say maybe the library in your town doesn't allow pets, but they allow individuals with disabilities to be accompanied by their service dogs. So, for example, someone who's blind would be able to use those facilities while they're being accompanied by their guide dog. A second example of a reasonable adjustment or modification might be that a city park doesn't allow any motorized vehicles on their rec paths, but a resident who uses a power mobility scooter would be permitted to use and enjoy those paths. And then a third example would be, for example, a museum doesn't typically allow food to be brought on the premises, but they make a reasonable modification for a visitor with diabetes who may need to bring snacks with them. Um, okay, so that covers effective communication, reasonable modification. Let's move on to slide number 9, Title II enforcement deadlines. Here's the part we've all been waiting for. So the breakdown here basically is that state and local governments that serve more than 50,000 residents need to be in compliance by April of 2026. State and local government entities who serve fewer than 50,000 residents need to be in compliance by April of 2027. All right, and we can move on to the next slide, please. And I think at this point, we've reached how can accessible web help you meet your compliance goals? Do you want to go ahead and take this one, Mackenzie?
Absolutely. Yes. So Accessible Web has a bunch of products and services that are very helpful for addressing your accessibility needs, such as web accessibility software, which are tools to automate and facilitate continuous compliance with updated accessibility standards so that your website doesn't get out of date and it remains accessible. We have consulting and training with expert guidance and training sessions on implementing and maintaining accessibility standards. We have accessibility audits. So our team, including members like myself, conduct comprehensive evaluations of web and mobile applications to identify conformance gaps with the ADA Title II and as well as other regulations across the world. We also have VPATs, which are voluntary product accessibility templates, which are documents to illustrate how well your website or your product complies with the WCAG accessibility standards or other accessibility standards. And these documents are essential for procurement processes.
Yeah.
Yeah, and you can also download our ADA Title II PDF resource online as well.
Thank you, Mackenzie. Yeah, so as I mentioned in the beginning, I did drop a link to register for RAMP, which is the software that we offer. That's kind of our central platform. We have an associated Chrome extension, so the Chrome extension is free. RAMP, we have a 14-day free trial, and then there's varying plans depending on the size of your organization, your websites, and your other needs. And some of those subscriptions do include additional expert support and consulting time, as mentioned. So if you have any questions, whether it's about our services, about accessibility more generally, or about Title II, please feel free to drop them in the Q&A section now.